All right, I'll call it. This is case number 822-859-490Z. This is Wesley Robertson versus Kody Gorden. Could I have appearances, please, starting with plaintiffs and counter defendants' counsels?
Good morning, Marjorie Hauf on behalf of the Robertsons.
Good morning, Rebecca Mastrangelo for the Robertsons as counter defendants.
All right, good morning. All right, Mr. Young?
Good morning, Your Honor. Loren Young for Michael Stiles.
Okay, Mr. Backus on blue jeans?
Yes, Your Honor. Gene Backus, bar number 473, appearing on behalf of ADJ Baseball, LLC.
Okay, Mr. Brown on blue jeans?
Good morning, Your Honor. Cameron Brown, bar number 15876, covering for Attorney Friedman on behalf of Fraser Inouye.
Okay, very good. I think we have appearance for everyone. Is there anyone else, additional counsel that would like to make an appearance?
Yes, good morning, Kate Ludwick, bar number 15955. My camera for defendants Kody Gorden and Tigers Baseball.
Okay, very good. I think that's it. Okay, so you all can be seated. All right, so thank you to everyone for getting me all of your things. I have reviewed, maybe not with a fine-tooth comb, but I did a first pass on everyone's documents, including your status reports, the supplements that you previously made and served on one another, as well as the requests for production, which I assume have been served on their on the respective targets of those requests. So let me start with plaintiff's counsel. Both of you, I guess. Can speak as needed. So, Ms. Hauf, I did read your status report. Thank you very much for that and for providing, memorializing the issues, I think, which you had previously brought to light about the iPhone 11 issues that Mrs. Robertson had. You also submitted your supplements. And you have served your request for production, I think, on all sets of defendants, correct?
Correct.
Are there any issues you need to raise with the court today?
There is one issue that we had some confusion with, Your Honor, with regards to Mr. Gorden and ADJ. We seem to have a situation with regards to that Instagram account that is going to be the main subject of the transfer of information.
So let's just clarify for a second. I imagine there's two. Well, I imagine Mr. Gorden has an Instagram account, right, for the Nevada baseball team, right? Are you also referring to a another Instagram account that Mr. Backus's client might maintain?
There is, so the Instagram account that Mr. Backus disclosed is actually a Twitter account, so we don't have, so we do still need that Instagram account. What he disclosed, like I said, when we actually looked it up, was a Twitter account. And then we have a situation with the Rawlings Tigers LV Instagram account, where Mr. Gorden says he doesn't have access to it, and ADJ Baseball says they don't have access to it. So somebody had to have had access, has to have access to that account, which wouldn't be obviously our client, so we need to know who that is, so we know the appropriate.
Somebody is the owner and custodian of that account, yes. I imagine. Somebody set it up.
Yes.
Okay. I don't know. Yeah. Nor
do we. So that would be the one thing, so that we can appropriately address the written discovery to the right entity for that.
Have you asked informally, at least, counsel for Mr. Gorden and then counsel for Mr. Backus if they know who owns that account?
I did not, Your Honor, because it just kind of came to my attention this morning when I was preparing for this hearing. I realized that because this is the other thing in Mr. Gordon's actual disclosure, like in his ESI disclosure that you ordered, he doesn't address that account other than he had the forensic examiner look for information on it. But in his actual 16.1 disclosures, he says he doesn't have access to that account. So those two things were inconsistent to me, and I just realized it this morning. So no, I didn't mean confer with them on that issue.
So there's a few different things here, which I'll ask Mr. Gordon's counsel about as well. There's a difference between not having access and not having ownership of an account, right? That it could mean that you're not the owner account. It could also mean you're the owner, but you've forgotten the password. You can't retrieve the password, so on and so forth. So I'll clarify that in a moment. But if Mr. Backus and then if Mr. Gordon's counsel, meaning if their clients don't know who owns the account at the end of the day, I think your next course of action, I don't want to tell you how to run your cases, you're probably going to have to subpoena Meta. Because nobody knows who owns it. You're going to have to figure out who owns and controls the account. I don't know if there's anything on the account page that might, I haven't looked at the account page. I'm not allowed to. So not allowed to do my own research. I don't know if there's anything on the account page that suggests who might own it. And I don't know if you've taken a deep dive into the account page. Sometimes you can tell by who the followers are, who they're following, and who's commenting who might own the account, if it's not any of the parties here.
Sure, and I have not yet done that, Your Honor.
Okay. All right, so that might be easier than subpoenaing Meta if you're able to figure that out.
Right. I'm assuming they don't already know, and that was, like I said, I'm assuming they know what happens with that.
Sometimes you have to ask the right question,
Yeah.
even though everybody knows the information you want. Sometimes you have to ask the exact right question. Let me turn to counter this. I'm going to butcher your name, especially right now because I'm getting over a cold.
Quite used to it. Mastrangelo.
Mastrangelo.
Correct.
Okay, so it's Master Angelo.
Pretty much.
Okay, now I'm going to remember it. Okay. Do you have anything to add?
I don't have anything to add.
Okay. All right, very good. Okay, Mr. Young, since you're here in the courtroom, I took a look at your client's disclosures as well. Thank you very much for those. We flip back to, have you had litigation services evaluate the issue with the iPhone 12, which apparently also emits more radiation than it's supposed to, at least in Europe, and so they're doing a huge recall?
Did not know that.
Yeah.
But what litigation services has told us is that they're working on, they believe that the iPhone 12 that broke during baseball practice was backed up before it broke.
Okay.
So they're working on getting that back up because that was then transferred onto the iPhone 10. So they're working on confirming that. My client still does have the iPhone 12. He told me, so I'm going to take possession of that in case we need it.
Okay.
But so far, they said that they've been able to access the cloud account to download all that data and as well as the G.
Okay, great. So he was using the iPhone 12, it broke, and then he went back to using the iPhone 10. And they just, when they revived the iPhone 10, they used the backup to revive it.
And they told me that the same email is on both phones.
Okay.
So it should be the same stuff.
All right, excellent. And then did you also, I know you had your supplement, and then you also sent out your first request for production, right?
Correct.
Okay, very good. Is there anything you need to bring to the court today?
The only thing that, I'll follow up with Marjorie later. Issue of the iPhone 11 that got reset to factory settings. I'm learning all this stuff from the experts, is that I would be curious if that phone was backed up before it was reset to factory settings, because if it was, that should be accessible through the iCloud account and be able to get access to that.
I think Ms. Hauf may have addressed that. Ms. Hauf, did you address that in your status report? I thought you did.
Yeah, I think we did. So what we know about that is that it was not backed up to iCloud. At least the parts of it were, but the text messages were not backed up to iCloud. But just like Mr. Young had stated, we still need to look into when she got her new phone, if they transferred all the data to the new phone, and then before they restored the old phone. So we have to look at that same issue that Mr. Young is describing on his client's phone.
Okay, meaning when she bought her iPhone 12 or 14, I assume not 15, before she gave her iPhone 11 to her son, they may have transferred the data to the new phone.
Right, and that's what we need to have the forensic examiner look at.
Okay. All right, very good. Let me go to Miss Ludwick on blue jeans.
Yes, Your Honor.
Okay, I also took a look at your status report. It sounds like you all are moving along. I know that you obviously raised the issue, which I think we're all aware of here, which this was an extramarital relationship. So I don't think it comes as a surprise to anyone that people were deleting their messages and pictures and whatever else may have been on their phone. But it looks like you are preserving what you need to through HOLO and what you're able to. It also looks like you served your first sets of requests for production. Is there anything that you need to bring to the court today, Ms. Ludwick?
Nothing additional, just the kind of same issues that, we've done what we could with, what Mr. Gordon presented to us. Obviously, we weren't able to recover things that were deleted before then, whether some of that can be recovered from Meta directly or, we can, address that as it comes. But Mr. Gordon's willing to do that as well, but nothing additional that,
Are you able to shed any light on this Instagram issue for the account that was attached to Mr. Gordon's baseball team?
is this in reference to the Rawlings Instagram account or the 643 baseball account?
Ms. Hauf?
Both of them.
Both of them? So for the Rawlings Tigers LV account, which, I could be wrong, but I think it's natural to presume that Mr. Gordon would have been in charge of that account, or at least someone working for him would have been in charge of that account. Do you have any information?
That's my understanding that he was in charge of it at some point. He no longer does, and I know that it was connected to his phone. Like when we had an image, it was connected to his phone. But I honestly don't know. As far as the other 643 baseball, my understanding that's for his private baseball lessons. So I would think he still uses, but I honestly don't know. I don't have any additional information. I would have to check with Mr. Gordon.
Okay, I think part of Ms. Ludwick, part of what all the parties were supposed to do here at some point was that they were supposed to identify all the accounts all the social media accounts that they maintained and communicated with. With regard to these specific accounts, the 643 private lesson account and then the Rawlings Tigers LV baseball account, I'd like for you to go back to your client and specify, is he the owner of the accounts? I guess 1. 2, does he have access to the accounts? If not, can he obtain access to the accounts? Like, for instance, if the reason he doesn't have access is because he doesn't remember his password, is he able to reset his password and gain access? And 3, if he's unable to do that, an explanation as to why he's unable to do that. And I'd like for you to supplement your status report with that information to all counsel, because I think those accounts are, at least the Rawlings Tigers account is at kind of the centerpiece of some of the allegations here. So would you be able to, do you think you would be able to do that within 2 weeks, Ms. Ludwick?
Yes, I can do that. I can contact Mr. Gordon. Are we looking for a supplement for just the Instagram accounts? I know the Rawlings account is kind of the most important, but
yeah, I think the 2 Instagram accounts is what's at issue here. The Rawlings Tigers LV baseball and then the private lesson, the 643 account. Is that correct, Ms. Hauf?
Yes.
Okay, very good. So we don't have. Do we have another date in this?
There was one other issue with Mr. Backus's client. In his ESI disclosure that
I'll
was
get to
ordered by
him
this
in-
court. It said not. Oh, okay. I'm sorry.
I'll get to
I thought
him in
you
a
were
second.
done.
I'm just doing
Sorry.
Mr. Gordon
Sorry.
right now. I'll ask you to supplement Ms. Ludwick by the 3rd, October 3rd, and to also circulate a copy to the court. And we'll do an in-chamber status check on October 6th for that supplementation and receipt by the court of the supplementation.
Understood. Yeah, we can supplement that.
Okay, thank you, Ms. Ludwick. Is there anything, I may have already asked you this. Again, I'm sorry. I'm getting over a horrible, I don't know what type of cold or flu this was. You didn't have anything to raise with the court, correct?
No, nothing further.
Okay, very good. Mr. Backus, let's go to you because I know you have an 11 o'clock deposition, and if you need to jet, I want you to be able to
Thank
jet.
you, Your Honor. Thank you, Your Honor. I can categorically represent to this court that my client does not have ownership control of either of the Instagram accounts, the Rawlings Tiger LV account or the 643 baseball account. Our understanding is, and it's not even a direct understanding, but our understanding is those were Kody Gordon's accounts. We have disclosed in our supplemental disclosure all the accounts that ADJ Baseball has that are not even relevant to anything going on in this case. Certainly they're not the fulcrum of the focus of this case, of the posting of nude photographs or messaging between Kody and Brittany or any of the other individual defendants. My client's only involvement in this case really came late in the ongoings when Wesley Robertson contacted him and had some communication with him. I'm sure why we're named in this lawsuit, but I can categorically represent to the court that we have no ownership or control over either of those accounts. We have disclosed the identity of Facebook accounts, TikTok accounts, YouTube accounts, Twitter accounts that Rawlings Tigers, that ADJ Baseball has for general, promoting of the baseball program, but none of it has any relevance to the issues in this case.
Ms. Hauf, I do see, and maybe I misunderstood you, I do see some Twitter accounts that were disclosed, but I also see some Instagram accounts that were disclosed. Were you unable to pull up the Instagram accounts?
Correct. They go to Twitter accounts. Apparently. According to people who understand social media.
Does anybody care? Does anybody have any objection to my going on Instagram right now and attempting to pull up these accounts? Okay, hearing none. Let's see if we can figure this out together.
I can see if I can get some more information from my paralegal on it if need be.
Okay. So there is a Rawlings. I don't know if this is the correct Rawlings Tigers account. However, there is an at Rawlings Tigers account on Instagram. It says Rawlings Tigers Baseball Sports Club. Educate, train, grow the game. Rebuild players located in Baldwin, Missouri. So I don't know if that's for the national one, but I see, I see Mr. Backus nodding his head yes. So it looks like there is an account.
Apparently, the one in there, the one identified in their fourth supplement goes to a Twitter account, and I apologize because I don't look like I have that supplement with me.
It's definitely here. I can show you. But if you just do the search button on Instagram and you type in Rawlings Tigers, it is at Rawlings Tigers.
I think the problem, Your Honor, that counsel may have had or her staff may have had, the Twitter account is at Rawlings_Tiger. The Instagram account is at Rawlings Tiger without an underscore between the two words. So I think maybe that is how that happened. They got the Twitter account instead of the Instagram account.
I was also able to pull up the recruiting page, which is at Recruit Tigers, which on Instagram, which refers back to at Rawlings Tigers.
I'll take another look at that. Thank you, Your Honor.
No problem. Okay, so at least those two we were able to pull up. Mr. Backus, I did take a look at your I did take a look at your supplement. I did take a look at your status report. Thank you very much for that. And I did take a look at your requests for production. Is there anything that you would like to raise with the court today?
Your Honor, the only point that I would like to raise to the court, and something that I thought you had directed the parties to do, and that is to have full compliance with 16.1 in the subjects of information relating to each of the individuals that were disclosed. The plaintiffs in their third supplement have failed to do that. They have done what a lot of people do, and that is whenever they list somebody, I'll just pick one out of the blue. Kody Gorden is expected to testify as to the facts and circumstances giving rise to this litigation, including but not limited to liability, causation, and damages. That diatribe is on virtually every one of the people that they set forth. So I don't think that is adequate to comply or comport with 16.1.
Ms. Hauf and Ms. Mastrangelo, I tend to agree with
Your Honor, my
Mr.
understanding.
Backus. You've got to identify the subjects of information.
No, and Your Honor, and again, I don't have that disclosure with me. With my understanding, that was the purpose of the last hearing, was to review those supplements and bring that up at that point. If Mr. Backus has some, I don't think our third supplement was our last supplement. So I don't know. I'm not prepared to talk about that today because I thought that was the subject of the last hearing. But I'm happy to discuss it with him if he'd like to give us a call about that.
So this is what I have before me. I actually don't have the third supplement. What I have is the second supplemental disclosure of witnesses and production of documents. And then I have, the way this was printed was not. And then I have, from Ms. Mastrangelo's office, I also have their disclosures. I think, so I understand why both of you are in this case. You think you can do one set of disclosures? Or will you all be doing kind of your own thing with regard to discovery?
I think we need to do separate disclosures, Judge, because my representation is confined to the counterclaim.
Okay. All right, so, but
Your Honor, the plaintiff's third supplemental disclosure was just electronically served September 18, so it's the last thing that I saw that they produced. I don't know of any fourth supplement that would have comported with this court's directive.
And Your Honor, again, it could be wrong, but like I said, my understanding, because that was our last hearing. So I'm happy to talk to him about it if he wants to send me a letter or give me a call with regards to which he thinks are deficient, and we're happy to work with him on that.
well, I think that's what Mr. Backus is raising right now. I think Ms. Hauf and Ms. Mastrangelo, because I think that to the extent the disclosures are made on behalf of the Robertsons as counter defendants, I think those disclosures also are, they're slightly better. Slightly, because you do say communications and interactions with specific people. But I do, when we talked about this, I think 2 sessions ago, and then we briefly raised it again the last session, which was basically just to say, hey, has everybody made their supplements, right? We didn't really get into the depth of the supplements, which is why I asked everyone to forward their supplements to me. I think the point was to really try to meet the intent of 16.1 witness disclosure so we could try to narrow this case. And And I appreciate Mr. Backus's position, that that's difficult to do when you don't know what subjects of information a party thinks a witness has in his head, I'm guessing. So Ms. Hauf, if you or someone in your office could take another look at your supplements and take another stab at them to try to make sure that you're actually identifying subjects of information that a witness is expected to testify about, instead of just they're going to testify about everything that's in the complaint, or they're going to testify about everything that's in their counterclaim or whatever. I think that would be helpful here.
Sure, and if Mr. Backus wants to let me know which he feels, I mean, obviously he wants us to take a look at Mr. Gordon, if he wants to let us know which others he thinks are deficient, I'm happy to specifically
Sure.
look at those and see if I can.
I think Mr.
clarify.
Gordon I'm sorry, Mr. Backus, I think your position is that they're all deficient.
They are. It's just it's the canned boilerplate answer for every single designated additional party. They also do the thing that drives me crazy, and that is listing an entity and saying a 30B6 of the entity, which to me is meaningless, because unless you have a 30B6 notice and you actually set forth topics, you have no idea what the subjects are that entity is going to be referencing. So I don't know. I think they intend to have a custodian of records and not a 30B6 designation, but that's minor. I'm more concerned about what each of these people really know or they think they know.
Well, take another look. Look, I'm taking a look at it right now, Ms. Hauf. Some of it I think is fine. Mr. Backus, I think what they've done is they've done a belt and suspenders, and what they've said is this person is going to testify about everything, including but not limited to, now let me give you some specific things. And my guess is the reason that Ms. Hauf has done that, at least with some of the witnesses, is because she doesn't want to lose her right to have witnesses testify about things that they may not have included. So I agree with you. Some of these witnesses are deficient. Some of them are, they are specific. Like for instance, I'll just pick one out. Alexis Gordon. Alexis Gordon is expected to testify as to the facts and circumstances giving rise to this litigation, including but not limited to details about her relationship with defendant Kody Gorden, her conversations with Kendall Wayne, text messages and direct messages she personally read and witnessed, the dissemination of plaintiff Wesley Robertson's private images, and payments made by plaintiffs to defendant Kody Gorden. So that's broad, and then it narrows down some. So for
Yeah, I don't have a problem with that, Your Honor. It's just the first 25 are canned. In item 26, and I'm looking at the third supplement, you're looking at the second, but in the third supplement, they do what I think the court asked to be done. For certain individuals, they tried to expand upon whether it's Kevin Smoot or Kyle Dellinger or Tiffany Gain. They went through and they did more detailed statements of what they may know. I agree, they did.
And I know you don't have these in front of you, but he's correct. For the first 24, it's actually 24, you do state, you kind of parrot this phrase, witness is expected to testify as to the facts and circumstances giving rise to this litigation, including but not limited to liability, causation, and damages. So you don't do what you do for 25A through K.
So you want us to supplement our first 24 witnesses with more detail?
Yes. Okay, Mr. Backus, anything else?
That's it. Thank you, Your Honor. I appreciate your allowing me to participate here.
No problem at all. If you need to run, that's fine as well. I know you have I know you have one of your colleagues here in the courtroom. Okay,
I do. I have a deposition starting right now. So thank you, Your Honor. I will excuse myself.
Okay, Mr. Brown, how are you?
Good. How are you doing, Your Honor?
Okay, last but not least here, I also received your Your status report, thank you very much for that. It sounds like you and your client have done what you need to do to try to extract and preserve your ESI data, and that you've also served your request for production. Is there anything that you'd like to bring to the court's attention today?
Not necessarily, Your Honor. I think we're just waiting for Hollow to go through and image all of the accounts, emails, texts, everything else that he provided to them. So probably once we get all of that back and have the opportunity to review that, then we might need to do some targeted interrogatories for possible depositions, but we just won't know until we're able to get all of that information back and see exactly what is, what they provide to us.
Okay, so I know everybody has requests for production that they have to answer at this point. I think those are generally going to be due towards the end of the month, maybe beginning of next month, if I saw the service dates correctly. So what I'd like to do is I'd like to give you all enough time to respond to the request for production, have a meet and confer on any objections, and then get your motions, any motions you need to file on file to compel production. So, or a motion for protective order if you think these are overbroad. How much time do you think, Ms. Hauf, I'll start with you, and Ms. Mastrangelo, how much time do you think you'll need for that? 6 weeks from today?
That should probably suit, maybe 8 just to be safe.
Okay. Ms. Mastrangelo?
Expect, there's almost always requests for extensions, and that's my concern.
That's fine.
Okay, all right, Mr. Young?
You're thinking of 8 weeks from today?
Today, because what I'd like to do is I'd like to, the next time we meet, if there are lingering disputes, I'd like to be able to hear those disputes in motions. And what I would expect is the motions be filed on order shortening time so that I could hear them by the time that we're all together on whatever week, 6, 7, or 8.
Yeah, I think 8 weeks should be plenty of time to get all that.
Okay, Mr. Brown?
I believe 8 weeks should be fine as well, Your Honor.
Okay, Ms. Ludwick?
We agree with 8 weeks.
Okay, I'm sorry.
Oh, it's Miss Reese. I believe we would be okay with 8.
Okay, so what's 8 weeks from today?
November 14th.
Okay, November 14th. What's 2 weeks prior to that time?
October 30th.
Okay, so any motions for protective orders or any motions to compel need to be filed by October 31st. And if you file them on October 31st, you need to do it on OST. Okay, and I'm going to hear those on November 14th. Okay, and you still need to meet and confer, of course, before you file those motions.
And is there a time for the hearing on the 14th?
Give another special set. What do I have that day? So, okay, so we're going to put you at 9 a.m. if that's okay, counsel. It'll be a special setting. I'm slated for trial that day, and we'll just start the trial late once we're done with your case.
And Your Honor, as far as other discovery is concerned, are we still limited to this stage? Let's get through this stage before we serve anything new.
Yeah, let's get the documents out before we start doing narrowing devices like interrogatories or depositions. Once we've got this first phase in universe of documents settled, we can move on to another phase of interrogatories. Any requests for admission that you want, any depositions, first large phase depositions that you'd like to take.
And I think we were going to do a settlement conference before those depositions. I think
Now,
is
what did
we
you all
talked
decide
last
about
time.
that? Have you all talked about it?
No.
Okay, let's talk.
I don't know if there's a consensus on the defense side to do that. I know it was brought up initially at the beginning of the case.
Okay, well, let's take a poll. Mr. Young?
My client would be not, I don't think he's very interested in a settlement conference. I mean, he's more interested in getting dismissed from the case. I mean, I think you know our position on this one. So, I mean, I think it'll really be dependent upon what we get from the responses to POD, or production of documents.
Okay, all right, let's take another poll. All right, Ms. Reese?
Yes, I believe we're in the same position where we're also looking to get out of the case. So I'm not sure how Mr. Backus feels about entering into settlement at this time.
I know he wants to get kicked on personal jurisdiction, so I probably know Mr. Backus's position. Mr. Brown?
That is probably something that Attorney Friedman would be better able to answer. I don't know if he's had conversations about that with our client, so I just don't know, Your Honor.
All right, Ms. Ludwick?
Yeah, I think it's still too early at this point to say how open Mr. Gorden would be to settlement negotiations. So that might change, but I think at this point it's premature to say.
Okay, so this, Ms. Hauf, this is Ms. Mastrangelo. This is what I suggest. I suggest we get through this first round of documents, then I'm going to revisit the issue. I think Mr. Backus's client might be in a unique position because of the lingering personal jurisdiction issue, which I know I imagine he's going to. I don't want to speak for him, but I imagine he's going to raise again once this round of documents is done. The other defendants have, as far as I know, answered the complaint. So maybe there are ways that they will seek to get dismissed from the case after this first round of production is done. Maybe there's not. I don't know what they have in mind at that point. But you know, it's very. I don't think we're going to be in a position, other than the personal jurisdiction issue. I don't think we're going to be in a position for summary judgments in this first round of documents. So I'm not sure. And the time for 12b5 motions has come and gone. I heard those. I rolled on those. And so, you know, defendants may have other motions to make. I don't know what they are, but what I would suggest is let's revisit the posture of the case in about 8 weeks. Okay.
I guess, Your Honor, if you wanted to continue that poll to the other side, because Ms. Mastrangelo's got defense of all of the cross claims against them, which would have to be part of that resolution. So I don't know what their position is on trying to settle those claims.
Oh, I forgot about you, Ms. Mastrangelo. I'm sorry.
Your Honor, I want to say about 3 months ago, I sent an email to all the defendants. I excluded my co-counsel because I just wanted to see what the defense thought. And I'm fairly certain that everyone responded that they would be interested in a settlement conference after this first round of, you know, let's get the social media stuff, let's get all the ESI. And then everybody responded favorably. So I'm kind of surprised now to hear that nobody wants to do it when, you know, I had those email communications, which is why I asked my associate, Sean Payne, the last time he was here to raise that with Your Honor. So I'm happy to reach out to all counsel again. I mean, I definitely think we need to wait till we get the documents and see what, so everybody knows what's out there. Although, you know, we all know what our clients have said, but sometimes paper is different. So, but yeah, I think that we would be interested in trying that because once depositions start, I mean, it's one thing that all the parties need to pose, and there's probably, I don't know, 6, 7, 8 parties that need to pose. But after that, there are dozens of depositions. And like Your Honor said, nobody's getting out on summary judgment anytime soon because it's a very fact-intensive case. So there are going to be factual questions and disputes. So I think from a cost perspective, it makes sense to at least give settlement conference a try before we start spending tens of thousands of dollars on depositions, which are going to be voluminous and maybe even out of state. So that's my 2 cents.
Hey, look, I encourage everybody. I think I encouraged you all after the first time we were all together to think about settlement in a case like this. I understand defendants' positions, by the way. Don't think I'm not insensitive to it. I understand, you know, especially Mr. Brown and Mr. Young, I understand that your clients feel that they've been unnecessarily dragged into this. And Ms. Reese, I know your client feels they've really been unnecessarily dragged into this dispute. So don't think I'm insensitive to that. But I would encourage you to revisit the issue after the first round. There may be, and I want to make sure I temper my comments appropriately. There may be bases by which your clients could get dismissed. I don't know what those are. I don't want to foreclose those at all. The only thing I'll say is that summary judgment, I can't predict the future, but if we're in the middle of discovery, of course, plaintiffs are going to have the right to make it used to be 56F, I think it's 56D now, affidavit. So it's very difficult for courts to grant summary judgment in the middle of discovery, unless the discovery just shows not only undisputed facts, but also that further discovery will be useless. I've granted that before, by the way. I recently granted a summary judgment where I said there's no amount of discovery in this world that's going to change the undisputed facts before me today. But I think that's more of a rare instance than it is a commonplace instance. So talk to your clients and then we'll convene again in 8 weeks. Okay? All right. Thank you. Have a good day, everyone.
Thank you, Your Honor.
Thank you, Your Honor.